Hello and welcome to this episode of Law for Lawmakers. I'm Fiona Rutherford, Chief Executive of Justice, the UK's law reform and human rights charity, working to create a fairer system within everyone's reach. This podcast is based on our Law for Lawmakers guide, which helps repair the cracks in the UK's political foundations by giving every MP the tools they need to act as custodians of our democracy. The podcast will explain key legal and constitutional principles to help politicians of all parties and their staff review new laws, table and write amendments to bills, support their constituents and much more. But this podcast isn't just for parliamentarians, it's for anyone who cares about the law and how they're made and how they're upheld. Each episode brings together leading voices from law, politics, public life, to explore each of these different principles that underpin our democracy and explain how Parliament can help to uphold them. In this episode, we're looking at how Parliament and its role in our Constitution, particularly in relation to the balance between power and principle. The UK's Constitution is unwritten, but its foundations, parliamentary sovereignty, the rule of law, and how it interacts with other branches of the state, such as the judiciary, shape everything from legislation to individual rights. These principles affect daily life, from challenging housing decisions to seeking justice after a crime, or simply understanding your rights. To explore these themes, I'm joined by the Right Honourable Dominic Grieve of King's Counsel, who has been a defining voice on constitutional law and the rule of law in modern Britain. Dominic is a barrister and former Attorney General for England and Wales, served as an MP for Beaconsfield over 2 decades, and chaired the Intelligence and Security Committee of Parliament. You played a pivotal role, Dominic, in debates in Brexit, the Human Rights Act and the UK's relationship with international law, and you continue to speak and write widely on constitutional reform and democratic accountability. So welcome to you, Dominic. We're going to go through some of the areas that I've touched on already. I'm going to start with understanding the UK Constitution. We know that the UK has what's described as an uncodified constitution that's built on principles, on conventions and statutes. But why does this matter for parliamentarians today?
It matters because it is quite complicated and it's worth spending a little bit of time working it out. Although a lot of it's unwritten and is therefore conventions. A lot of it is written, but it's not written down in one place. It may be written down in laws which are regarded as being very important, but which can be changed. It may be the standing orders of the House of Commons, something which I think people very often don't understand, and I certainly didn't pay much attention to in my early years in Parliament. But it has to be said that over the problems in relation to Brexit and the crisis that unfolded afterwards, I came to realise that the standing orders of the House of Commons are extraordinarily important. They are, in fact, the mechanism by which the Constitution is delivered. So it is important to look at what those principles are, and they're actually quite easy to identify for the most part. But it's also right to say that they are not immutable. They are capable of being changed, and I'm afraid they are actually capable of being subverted, particularly by a government that has a parliamentary majority, so that you could be taken to a very different place quite quickly by a government that decided that constitutional norms shouldn't be respected.
So talking of major or big majorities, your career spanned the new Labour government. That's when you started as a Member of Parliament, I think. You were in Parliament during its constitutional reforms, as well as the successive Conservative governments of which you were a key member. How have you seen the UK's constitution shift and evolve over that time?
There have been 2 great shifts under Labour. The first, obviously, was devolution, which in a way, has proved itself. I know that it has its ups and downs, and there are some areas which I think remain rather uncertain. But that was a devolution of power to Wales, Scotland, and Northern Ireland. Different forms for each, which has changed the way we're governed and where decisions are made. But ultimately, sovereignty does remain at Westminster with the government, because Westminster could change the devolution settlements at will. The second change that Labour brought in, which I think was much less desirable, is that for reasons which I've never wholly understood, Tony Blair decided to embark on a Constitutional Reform Act which really wasn't properly thought through. And key to it was the abolition of the role of the Lord Chancellor, who was a very curious product of our history because it was a senior government minister with a lot of power, certainly influence within cabinet, who was also head of the court system and judicial appointments, and on top of that could sit as a judge in the House of Lords and was a member of the House of Lords and its Speaker, although being Speaker of the House of Lords was a rather nominal role. A very important player in terms of the rule of law and embedding the rule of law and rule of law principles into the way the government operated. And I'm afraid that the consequence of changing the office, he wanted to abolish it and then discovered it was so complicated he wasn't going to do it. But he amalgamated it first into a Constitutional Affairs Minister, and then later it turned into the Justice Minister and Lord Chancellor, which has created a departmental minister essentially largely shorn of the responsibilities for upholding the rule of law, despite the fact that the House of Lords insisted on putting in a clause requiring the Lord Chancellor to swear an oath of office to do exactly that. But the evidence is pretty overwhelming in the last 10 years that individuals have been appointed as Lord Chancellors who have had no idea about that aspect of the role at all.
So in terms of we're going to come back to devolution. You've mentioned, I think, an important element of how the Constitution has evolved, which I think is important to explore. But before we do that, thinking about parliamentary sovereignty and its limits, its limitations, it's often described as the cornerstone parliamentary sovereignty of our Constitution. And it's used a lot in the press, particularly during the Brexit debates and after that. What does the principle actually mean in practice?
In practice, it is the product of a 17th century tussle between Parliament and the King and the King's ministers. Now, the King doesn't come into it anymore because under our constitutional monarchy, all political functions are discharged by the ministers. But what it does mean is that ultimately Parliament is superior to the executive and can show that by getting rid of an administration and replacing it with another, by blocking legislation that a government might wish to introduce, by the power to hold ministers to account by asking questions in Parliament. And I think, and this probably distinguishes us from the US Constitution, by the fact that actually, unless the power has been given to them by Parliament, or it lies in those very limited powers which remain under the royal prerogative, ministers cannot act without parliamentary approval. So that's the principle. I'm afraid I think that principle is in danger of being perverted because it's been turned into a principle that Parliament can do whatever it likes. Well, I suppose on one level it can. If the Parliament were to pass a law saying that we have to worship the moon every Tuesday, that would be the law of the land if it was signed off by the King. But the reality in our Constitution, and it's been present for a very long time, is that there are convention constraints on what Parliament should do, which frankly go back to Magna Carta, even go before the existence of Parliament. And they're also present in things like habeas corpus or the Bill of Rights of 1689. But of course, they raise an interesting question, which is, are they merely there because Parliament has decided they should be there and therefore Parliament could turn around tomorrow and decide to get rid of them? Or do they represent some rather more fundamental principle, which is that Parliament is supposed to behave in, dare I say it, a moral way, and that there are some liberties, particularly liberties of the subjects, which cannot be lightly interfered with, although the general view as a matter of law is that Parliament could do those things, and of course in time of national emergency has done so. But it remains an interesting area of debate, and from time to time the judiciary intervene to express disquiet where they think that Parliament is acting in a way that might appear to be improper. So I think it's an area of continuing debate, but I have to accept this is my personal view, and some of my colleagues in the House of Commons will be appalled to hear this and to say, no, we are sovereign. We can do what we like. It's never been my view about the fundamentals of the UK Constitution, but I accept that that's reliant on convention more than anything else.
You mentioned there what people might describe as arbitrary power. The example you gave was around worshipping the moon, or that being an example of someone using power in the wrong way. How does the rule of law in particular protect individuals from that sort of arbitrary power or working against the interests of the public?
The rule of law operates in this country, firstly, because we have an independent judiciary, and it really has been independent and properly independent since the beginning of the 19th century, and probably more independent today than it was then, certainly in terms of seeing its role in interpreting the law and protecting the citizen from the overmighty executive, particularly as executive powers have increased dramatically in modern Britain, because our society is so much more complex. 100 years ago, many people would have had very little contact with officialdom, whereas nowadays it's a commonplace. So the independent judiciary interpreting the law are absolutely key. And on top of that, we have common law principles which do reflect some fundamental ideas about liberty. But of course, they can be overridden by Parliament. But a rule of law state is a state in which arbitrary exercise of power does not take place, and which, if it does occur, it can be successfully challenged. And when it has been successfully challenged, the executive accepts that it has got to back off. Of course, the executive could then decide to use parliamentary power to pass a law to enable it to do something which was previously prohibited. But it's a very important check on executive power abuse. It's obviously not a check on parliamentary power, because ultimately the system operates on the basis that Parliament can enact legislation which will overturn judicial decisions.
So how does Parliament in particular play that role in safeguarding the rule of law?
Parliament plays that role, I think, because it's embedded or has been embedded in its DNA. So on the whole, if the executive is proposing to do something which parliamentarians are queasy about, you see it very quickly go to fundamentals. An example of this was when Tony Blair, worried about terrorism, decided he wanted to introduce 90-day pre-charge detention. I've never really understood why he wanted to do this, because I actually think the security services didn't think it was necessary, but he thought that this would be a powerful tool to prevent it. But the rebellion, which eventually led to it was the first time he'd ever lost a vote, in fact, almost the only time he lost a vote in the House of Commons with his big majorities, was because enough Labour MPs were sufficiently disquieted about the undermining of the principle, the fundamental principle, that you don't detain people for long periods without trial or charge, that it just foundered on the back of deeply embedded principles. And in the same way, curiously enough, the Conservative opposition, which was very law and order and worried about terrorism, even they worried about doing something which appeared to them to be, A, unnecessary. The situation wasn't serious enough to warrant it. But on top of that, they were just disquieted about the executive power that they were handing over if this were to happen. So I think it's a very good example of the DNA, if I can put it this way, in the system working in exactly the right way,
regardless of the fact it's written down or not.
Yeah, absolutely.
So separation of powers and checks and balances is the next topic I want to talk about, which we've touched on a little bit already. You've mentioned the independent judiciary, for example. The UK's separation of powers is not absolute, but how does this interplay between the executive, the legislative and the judiciary strengthen or weaken our democracy in your view?
I think when it's working well, it works very well indeed. I know that people talk about we don't have total separation of powers. But in reality, I think we do. The judiciary are not beholden to the executive, particularly now that we have a system in place for independent appointments, judicial appointments. We don't have elected judges as in the United States. And successive Justice Secretary, Lord Chancellors, even if I think that they may have some failings, have respected the appointment system. And there is a pool of talent to become senior judiciary members, which is sufficiently good to enable that to happen. And the judiciary is essentially self-regulating. Parliament does have the power to remove judges on a motion of both houses. It's not happened in modern history. I think it may have last happened in the 19th or 18th century early. So it's one could think of a couple of judges who may have resigned when it was suggested to them that this might be their fate. But I really think that it's very unusual. And they are independent. Now, you contrast that with some European countries, I have to say, where they're supposed to be total separation, but actually there's much more of a sense of them being executive function of the state, civil servants, whereas judges are not civil servants. It's quite clear that that's the case. So I think from that point of view, it works very well. Now, there are occasionally tensions, but it happens quite rarely. It's happened over one or two constitutional matters. It obviously happened over the prorogation of Parliament and over these residual areas of the royal prerogative. But the royal prerogative has been whittled away progressively over a long period. It's not to say that the judges should be interfering in executive decisions, but the principle that an executive decision, even done under the prerogative, is technically reviewable by a court has been established since the 17th century. So judges may say, we won't touch this because this is wholly political, but nevertheless they do have a right to look at it. So that's a very powerful check. It's also true that there's been at least one case in recent times where it was suggested that judges rewrote a statute because they didn't like the statute. And that was over the Black Spider letters of the then Prince of Wales and my role in it when I was Attorney General. Actually, I can understand where the judges were coming from. They didn't like the fact that Parliament had enacted a piece of legislation which allowed a minister of the Crown to override a decision of a superior court of record. I don't actually think it was intentional by Parliament anyway, but that was the closest we've come to a clash, and I think it probably had some lessons for both sides in it. So on the whole, it works well. Obviously, there's slightly some apocalyptic talk that there will be some terrible conflict between the two. And there had been talk when Boris Johnson was Prime Minister, he was going to defy court orders. But as was pointed out to him gently, I think at the time, by some senior civil servants, if you do that, Prime Minister, we're going to stop working for you. Yeah. So, interestingly, that I think is the absolute key. We haven't talked about the monarch, but actually, because ultimately the monarch is the foundation of the Constitution, it's the linchpin, that's where loyalty lies. And as long as that principle is maintained, the chances of an executive being able to usurp power and misuse it are in fact very limited, because to do it, they would at least have to corrupt the civil service first in order to achieve that aim. And there's no suggestion at the moment that that's happening at all.
Which is great to hear. I promised we'd come back to devolution, which you mentioned at the start, and we know that devolution has transformed the constitutional landscape. Again, you've touched on it already, but how should Westminster approach lawmaking in a way that respects devolved powers and conventions like the Sewell Convention, which maybe you might want to just explain what that is?
The Sewell Convention was simply the statement after devolution to Scotland had happened that the model was that, yes, Westminster did have the power to legislate, but would not ordinarily exercise that power in areas that had been devolved. It's a very important principle, otherwise you're going to subvert the devolution settlement. Equally, it's right that the Convention provides a mechanism by which you can ask devolved administrations would they like Westminster to legislate on devolved matters where it clearly makes sense and is a good use. There's agreement between the two administrations that this would be a good thing to do. And they then pass a Sewell motion which enables that to happen. So it's a perfectly flexible mechanism. Devolution, I actually think it's probably working reasonably well now, but the tensions in devolution are essentially political tensions. Firstly, it has to be said that when it was started under the Blair government, there were Labour administrations in Cardiff and Edinburgh and in London. And there was just a slight sense that issues around the settlement were being resolved by informal means, a bit like the old Soviet Union ran the nominally independent stance. So there wasn't a mechanism for that. And the test as to whether devolution works is whether it works when you have administrations which are of a different complexion in Edinburgh or London. Cardiff. The other aspect, obviously, is that as long as nationalism and independence is a major issue, it makes cooperation harder because inevitably at a political level, both sides are jostling because they don't trust each other with the level of trust that one would like to see between the devolved administrations and the centre. If we have to get past that, I actually think devolution would work very, very much better. But you do need some formal processes to make it work, and you have to have a very high level of mutual trust and mutual respect about what each of the parties is doing. I think we're probably closer there today than we've been for a long time, but we've certainly been through patches where it's been notably absent.
And do you think the conventions are robust enough between Westminster and the devolved administrations?
They are probably robust enough. And as I say, they should, given time, they should evolve of their own accord. So I think on the whole it's working pretty well. And at one stage, clearly in the post-Brexit crisis, because of the differences of view, particularly between Edinburgh and London, it was being played for political advantage on both sides in ways that is not very productive. If you want to have good, quiet government, you need to have understandings and let people get on with their own remit. Whereas actually what was happening is everybody was playing to the gallery.
Yeah. Talking of Parliament's role, as I mentioned at the start, the role Parliament has as guardian of constitutional principles, what are the practical steps that MPs and peers can take to uphold constitutional principles during legislative scrutiny, for example?
There's already, even within government, mechanisms to try to ensure that legislation meets constitutional principles. There's a legislative affairs committee, and every piece of legislation that's introduced has to be vetted by the departmental lawyers. And there's a whole series of things they should look at. Is there any retrospectivity, unusual use of powers, and of course now the Human Rights Act and the European Convention on Human Rights, does it offend those? And that then goes to the Attorney General's office, and the Attorney General signs it off. And if the Attorney isn't happy, in my experience, the law officer can turn up at the Legislative Affairs Committee and say, I'm not very happy with this legislation, and under the system, it goes back to be looked at again. But that's not to say that it then goes in some perfect condition before the House of Commons. The House of Commons can, if it conducts scrutiny properly, expose failings of constitutional principle. I have to say they're not very good at it. The House of Lords is much better at doing it. But that's what parliamentarians ought always to be doing, irrespective of whether it's their own government's legislation. Are there aspects to this that ought to give one cause for disquiet? And I suppose a good principle is do as you would be done by. Is this something which, if you may think it's right that people should be at the receiving end of it, but would you wish to be at the receiving end of it? And what does it say about the state of Britain as a rule of law state if this is to happen? So the classic problems at the moment are that we legislate by primary legislation to give vastly excessive powers to ministers under secondary legislation. And then this stuff just gets rubber stamped. It's the Achilles heel of our government system. It could be massively improved. I'm not suggesting you can get rid of SIs, because SIs are there to stay. We can't operate without it. Parliament would have to sit every day of the year. That can't work that way. But you could have better scrutiny of statutory instruments. You could have statutory instruments that are amendable. You could do lots of things to actually enable the statutory instrument process to work better. And one thing I'm absolutely clear about is that giving powers to create primary legislation by statutory instrument is a very bad thing and should be done very sparingly, if at all. And I'm afraid that is still happening.
What you're talking about is Henry VIII, or what's often talked about as Henry VIII powers.
Yes.
And I mean, I was tempted to ask actually in relation to your former role as Attorney General and as a visitor when necessary to the Legislative Scrutiny Committee.
Henry VIII power is something that I would note and I would flag up if it came along, and I would express concerns about. Obviously, it's then a matter of one's colleagues what they want to do about it. But on the whole, it's, I think, a very bad idea because it subverts Parliament's role. Although it has to be said that Parliament, and this has been one of the problems, that the way the House of Commons particularly works is all too often to roll over and not object to things which are in fact undermining of its own role. And that applies both to legislation, but we've also seen it progressively over its own standing orders. I don't want to get too bogged down in this, but I got very criticised because during the Brexit crisis, Parliament took control of the order paper to say, sorry, we want to debate something at a particular time. Well, in the 19th century, it was Parliament's right to do this. It shed it in 1906 because it was a big Liberal majority, and they got rid of it. And so when people say, well, this is a terrible novelty, what you're doing, legislating, taking control of the order paper and legislating when the government doesn't want it, the answer to that is, well, Parliament in the past did it. And this government doesn't have a majority to stop it. So perhaps that's a good reason why it should listen to Parliament a bit more. So these are areas, I think, where our constitution is quite weak. It has an assumption that it's binary. Parliament does whatever the government wants or gets rid of the government. My personal view is that Parliament has a right to do all sorts of things without getting rid of the government, including just saying occasionally to the government, please go away and think again.
So looking ahead, in an era of rapid political change, what do you see as the greatest constitutional challenge currently facing Parliament?
The greatest challenge facing Parliament at the moment is, and I'm afraid it does come from Brexit, but it's now around in other forms, which is that the will of the people is superior to the will of Parliament. And whilst obviously, ultimately, parliamentary sovereignty depends on elections every 5 years or sometimes sooner, and the public have the right to throw out MPs they don't want and to get the administration they want, the idea that Parliament is constrained by popular sentiment is one that is having, I think, quite a corrosive impact on its freedom as to how it conducts itself. After all, there are lots of rules in the House of Commons to protect MPs who may wish to say unpopular things, including things with which I might profoundly disagree. But they are there for a purpose. And the mood music at the moment, perhaps as a result of social media, is that we sort of have this strange process by which we vilify people one moment and then they're heroes the next, or vice versa. So there is an instability in our politics, which ultimately is quite marginalising of Parliament's role. And the other problem associated with it, and we can't escape this, is that if parliamentarians want to get a message across, rather than debating it in the House of Commons, where it is actually moderated by the process of debate, if you want to learn about your opponent's views, the best place to do it is to actually bother to sit through a 6-hour debate in the chamber of the House of Commons. You will learn a lot. And the reason you have these debates is because it's designed at least to make you understand the other person's point of view and therefore readier to accept a decision that you might otherwise not like. I always say to sixth formers, Parliament is not the place where majorities impose their will on minorities. It's the place where minorities accept majority decisions. And indeed, the whole of the ritual of Parliament, including royal assent in the House of Lords, is geared round doing that. But nowadays we live in a 24-hour media environment. It's easier for politicians to go over the road to Millbank, where the studios are, and to pontificate there than to actually bother to listen to other people's points of view. So the threat to our democracy is actually because we are no longer talking to each other. I know this sounds very odd, but if we bothered to listen to what other people are saying more and try to understand their point of view rather than just trying constantly to get an edge over them, I think we would find that our political processes worked much better.
Well, my last question was going to be, what piece of advice would you give to new MPs about engaging with constitutional issues? But it may be that might be one of the first things you say.
Listen to people and use the benefit of being in the House of Commons to mix with people outside of your comfort zone. This used to happen much more in the past. In my father's day in Parliament, they were always there for dinner. It was quite normal for people of different parties to sit down and have dinner together. They would gossip about the state of the nation, which is partly what you're there to do. Nowadays, you tend to sit segregated in tables, and that communication isn't there in the same way. And I do think, what I would say to new MPs is take an interest in the processes which have led to you having this particular role, the historic processes. Understand your powers. I think in many ways MPs underestimate the powers that they might have. All they have to do is go and talk to the clerks. The clerks will tell them what motions they can table and what they can't table and how they can bring people together. As I discovered, they're very helpful because they're neutral. They'll just give you the advice you need. And listen to your colleagues, obviously, but also to your opponents. And if you do that, I think people will realise how blessed we are, in fact, in this country. We have, for all its faults, and there are many governance problems that we have, but basically we have an extraordinarily benign constitutional system which avoids violence, political violence, which is very important because many countries have it, builds trust at multiple levels, and also enables, if people are prepared to make use of the tools, good scrutiny of legislation, and above all, where there is respect for the rule of law and the absolute fundamental principle that people should not be subject to arbitrary decision-making.
Thank you so much, Dominic, for sharing your insights and experience. Your perspectives have really shone a light on an area of public life that I know listeners will have found really insightful. Thank you for listening to Law for Lawmakers. For parliamentarians, understanding legal and constitutional principles is essential to sharing fair and just and effective laws. And these principles really matter to all of us. They protect our rights, they hold power to account, and ensure justice is within reach for everyone. Justice is a cross-party law reform and human rights charity working to build a justice system that is fair, accessible, and within everyone's reach. The Lawmakers Guide is designed to support MPs, peers, their staff, and many more in navigating complex legal issues, scrutinising legislation, and standing up for their constituents. To learn more about our work and to access the guide, visit www.justice.org.uk. And if you found this episode insightful, like and subscribe and share it with your colleagues and friends who care about the future of our justice system. I look forward to speaking to you on the next episode.